right, so we are going to be talking about the exclusive buyer agency agreement. So this is the agency agreement you would use in working with a buyer. We don't use, the only other option really would be a transaction broker, but today we're going to be talking specifically about the buyer agency agreement and what that looks like. So I'm basically going to walk through this, and if you have any questions, obviously, just let me know as we go. I'm going to see if I can make it a little bit easier.
Joseph, is this form number 130?
135.
135. Okay, cool.
Yep.
Thank you.
Yeah, so just so you know really quickly, if you look at the difference, so 130, I'll pull these back up really quickly. So 130 is exclusive right to buy buyer agency agreement. Actually, no, 130 is the one we should be looking at. I had the wrong one up. 130 is exclusive right to buy buyer agency agreement. Exclusive agency would mean that they could be represented by another agent. So we are going to be using form 130. Sorry about that. All right, so let's just go through this. It's pretty easy peasy, like it is with most of them. It's mostly fill in the blank. You're going to be looking at who is on the contract, right? This is going to be the buyer, and then you're going to name the broker in charge of Keller Williams Realty. That's where you put that in there. Now, as far as the purpose of this agency, this is where you do want to start putting some guidelines in there. Now, the question is you know, you don't want to make this too specific where you're not covered, so to speak, if they do go to new construction or something out in your area. But then you also don't want to be so broad that they're locked in regardless of where they are in the state, so to speak. You know, so from here, general description, I would, you know, put at that point, single family, condo, townhome, whatever they're looking for, their price range, general location, and then for preferred terms and other, typically we don't see a whole lot put in there. Okay. Broker's duties, this obviously maps out what it is that you're going to be doing for the buyer, right? Broker shall provide a buyer meaningful explanation of agency, which really should have been done before going through this agreement, right? You're going to talk about the different types of agency and shall use the broker's professional real estate knowledge and skills to represent the buyer in a diligent and effective manner to locate property which is available to purchase. Broker is not representing the seller. If the broker is not representing the seller, sorry. Broker shall represent solely the interest of the buyer in all negotiations and transactions of the property. If the broker represents the seller as well as the buyer, i.e. disclosed dual agency, I'm kind of skimming through these a little bit. The broker shall not disclose to the buyer information obtained within the confidentiality and trust of the fiduciary responsibility with the seller, nor disclose to the seller the information similarly obtained from the buyer. So basically, this is kind of helping you understand or helping you explain to the buyer what it would look like should there be a dual agency situation. And then D, the broker may represent other buyers who may be interested in the same property as the buyer upon the termination. That's an important one to go through right now in this market. So if I'm meeting with you, you know, I'd say, Renee, what this says is I do have multiple buyers with whom I'm working. And this is just a disclosure ahead of time that I may have buyers that are interested in the same properties that you are. And in that case, basically the confidentiality would remain the same. I wouldn't be disclosing to those buyers what you're offering, just as I wouldn't disclose to you what they're offering. We would just go in on your needs, wants, motivation, and then I would educate you on the market so you could make a good decision on moving forward. Buyer's duties. Oh, wait, sorry. I definitely skipped to the next one. And then the last paragraph under paragraph 3 or section 3 is basically just a small disclosure, a simple disclosure of what, you know, that I'm licensed. It says that you're licensed as an agent in South Carolina. Section 4, buyer's duties, right? This is the buyer agrees to. Now, the reason I go through these, guys, is not to read you boring language. This helps when it comes to putting together your buyer preparation, right? Or your buyer presentation. I do want to give a shameless plug. Let me see when it is. I think, is it tomorrow at 3? Is the buyer consultation class, how to bulletproof your buyer. This is a class that Lynn is teaching from 3 to 4:30. This is going to take this buyer agency agreement and basically put it on steroids. This is the whole process of start to finish when you get a buyer lead. It is fantastic. I'm not just saying that.
Just tomorrow, will it be held again in the
future? Yeah, she does it once a month.
Once a month, okay.
Yep. Yep. And it's one that you'll want to come back to. And she does share all the systems and forms and everything on there. It is a great class.
Yeah.
And that's a culmination of years of research. They call it R&D, rip off and duplicate. And then obviously some experience as well of what works. And it's super important in this market. Just really quickly, one of the things we talked about, we had a top 20% mastermind for the West Ashley office earlier today. The top agents were talking about a big struggle right now. Here's an interesting statistic. Since March 1st, 112 homes have gone under contract. 126 have gone back on the market.
Wow.
Right? So that means a lot of people are snapping up homes pretty quickly, but they're falling through for whatever reason. Now we're going to dive into those numbers a little deeper, but what that tells me is that buyers are pulling the trigger too soon, and or buyers agents are not preparing their buyers properly for expectations. And that's what a good buyer consultation will help you get through. But I thought that number was fascinating. So just something to keep in mind. Okay, so this goes through the buyer's duties, right? So 4A, work exclusively with the broker and affiliate licensees during the term of this relationship, right? So this is going to be viewing property, allowing the broker to identify property, negotiate for you, referring any inquiries that you've received from other real estate broker, or even saying, hey, if you find a for sale by owner, or if you do want to go look at new construction, all of that is great. Just let me know. I'd love to be the first point of contact on there. I'm not going to get in the way of you and your perfect home. So in the event you do find, a situation that I'm not involved in, or I'm not there with you, I want you to still see the home. Just, if you will, make sure I'm your first point of contact. And then it talks about some hold harmless stuff, which is always fun, right? You won't hold me you won't hold me liable for any incomplete, inaccurate information. If the seller fails to provide this, I can only relay information that they give. You'll assist the broker in the processing of identifying, negotiating, and contracting the purpose, which basically means that they're going to give you reliable information. They're going to participate in all of this side by side. And the reason this is an important time to talk about that is I've been speaking with a lot of buyer clients from a broker standpoint that seem to be kind of coming into the transaction as if they're working against their buyer's agent, not in collaboration with. And what I mean by that is they're hesitant to be in that collaborative mindset of, well, I'm not sure, let's just see what we can get the price for versus, disclosing all the information, that sort of thing. This kind of helps set the precedent. So like, look, this is you and me against the market. I'm on your side here. If I'm advising you on a higher price, it's not because I want to make more money. $25,000 difference in a sales price is not enough to make or break a commission. I'm advising you what's best in this market. Right. So we just want to set that tone. Provide the broker and its licensees the general nature, location. This will be things that you go through in your buyer consultation. And then authorize the buyer's attorneys and the settlement agent to furnish the broker copies of the final settlement statement. Again, this is mostly permission to disclose information. Okay. So a bunch of legal stuff out of the way. Let's jump into section 5, because this is where we're going to spend most of our time today. So section 5 talks about basically there are two different ways that you are paid as a buyer's agent. Okay. Now the bold I am going to read: brokerage fees will be deemed earned when the buyer is under contract to purchase and the property presented by broker or negotiated by the buyer. This fee will be due and payable at closing or upon buyer's default. If buyer defaults, the total commission that would have been due broker will be due and payable immediately cash from the buyer. Now, of course, you're not going to start with that. Right? I earn my commission when we go under contract. So if you mess up, I get it. I don't know many agents that have actually pursued that. But you do want to go in and say there are two different ways that the agents get paid. Number one, section A is a brokerage fee. And then section B is that the buyer pays me either at closing or beforehand. So the two different ways I'm paid a brokerage fee. The first one is option 1, which is not used as often. And the second one, option 2, is the one that's used 9 times out of 10, right? I'm going to start with 2, and the reason is because that's the one we know the most, and then go back to 1, so it'll help explain the difference. So the brokerage fee option 2 is a broker shall obtain a payment of the brokerage fee out of the transaction. Broker shall be paid by the cooperating broker as stated in the MLS or as agreed to by the broker and cooperating broker, or as agreed to by the broker and the seller in a for sale by owner situation. Broker shall not be responsible for, or buyer shall not be responsible for paying broker the brokerage fee. This, for most of you, 9 times out of 10 is what you choose, right? I'm going to get paid whatever I can negotiate out of the contract. What we're starting to see more of is option number 1. Option number 1 says the buyer shall pay a brokerage fee, which is the greater of blank or blank percent of the purchase or lease price. So what would happen is just for example, let's say, what happened to my screen here? Let's say you were to pick a number in here and write it in, and let's just say for this, no, it's not going to let me do it. For the example here, they're going to say, I want you to guarantee me 3%. So you're going to write 3% in here. Whoops. Let's say you write 3% in that one. Or you could put a dollar amount in here, but most people are putting in 3%. So what this says is if you choose to use me as your agent and I'm only going to get 2.5% out of the deal, you are agreeing to pay me the additional 0.5%. Right? It's basically guaranteeing the agent that they'll get 3%. Now, the reason that I spend time on this one is we are seeing a lot of buyers brokerage agents now, or buyers agents now that are using this. And when that happens, they're going to the listing agent to say, hey, I know that you're offering out 2.5%. Are you willing to offer more? I just need to know that because should my buyer decide to purchase your property, it may cost them a little bit more than it would a property that's offering 3%. Now, as a listing agent, a lot of people get a little sideways about that. They don't love it when agents do that. You got to understand, they're not doing anything wrong. They're just simply saying, hey, in my agreement, my buyer has agreed to make sure I get 3%. So if I'm looking at your house at 2.5% and another house at 3% and everything else the same, it is going to cost my buyer more to purchase your house. So are you willing to negotiate with your commission? They say yes or no. And then you at that point will still show the property. You're not going to not show the property because of the compensation. That would be against the law. And then you would say to your buyer, you know, you're going to owe me 0.5% on there should you decide to hold them to that. Does that make sense? Yes, Celeste.
Have you ever personally done that? And I mean, that just seems like with the buyers I've worked with, they would be kind of overwhelmed with that. I don't.
Yeah, I mean, it's most agents that I know that have that use it as a negotiating tool for the compensation offered in the MLS.
Okay.
So they go right, and then if the agent says, you know what, we're not, or the seller says, no, I'm not going to pay you more, then the agent opts to not hold the buyer to the difference.
Okay.
But I do know some people that will stick with it and they have their agent pay the difference. We met with an agent who's probably going to be joining in the next month or so with Keller Williams, who's about a $12-15 million producer, and they charge a fee on each one of their closings in addition to whatever they're getting from the buyer standpoint. So it's, you know, again, at the end of the day, it's all about value. If you're providing that value and you can sell the value, then you can do that. Now my personal preference is, and personally, what I've always done, what Lynn's always done, is we take option 2, right? And we get paid from the transaction. And if there's a difference on there that that we have to eat, then we eat it. I am not sitting here saying that's the end all be all on how to do it. That's just what we chose to do.
Yeah, absolutely.
Okay. All right. So part B, retainer fee. This is another option that you have, is you can charge a retainer fee due and payable upon the signing of this contract. That fee shall or shall not be credited against the brokerage fee. So you could say, hey, I'm going to charge you a retainer fee of $500, which means you pay that up front. And then shall or shall not be credited against the brokerage fee. So you could also say, however, then I'll credit that back to you at closing when we close. Not a terrible idea, right? Some people do that. And then the service fee is the buyer shall pay a broker a service fee of X amount. And then again, it's an amount that's due regardless of whether or not there's a brokerage fee. They would pay from there. Okay. Any questions? All right, easy.
When it comes to, I guess, figuring out these numbers, is there like a standard number, or how do we even know what number to negotiate, or how will we know?
Right. So, the first answer to your question is there are no standard numbers. So, it's the default. I have to say that all commissions negotiable. If you do, but what I will say is it's very common that it was very common, I should say, for a while that buyer's agents were being offered 3%. Again, always negotiable. I'm just saying what was most common. I will tell you in both market centers, we just got the numbers and I can look at them really quickly. If you look at, see if I can pull this really quickly. Can't remember if this is an actual vital sign number or not. No, I'd have to look it up. But, the average percentage of commission in each market center is closer to 2.6 or 2.7, which really is an indication that there is a compression or contraction on brokerage fees, right? It's not averaging out on that. So, for you specifically, it's up to you as to whether or not, you want to run your business. It's all based on how you run your business model, right? If you go through and you do your business planning, you do your economic model, we always are very conservative on the percentage. We base it on a 2.6 or 2.75. That way, if you get the lower end, you're still planning accordingly, right? From a listing standpoint, I would say that I would be negotiating to get 6%, offering out 3, keeping 3. I mean, I think that everyone is worth that. That's the value you provide. Should you decide to negotiate that at a different level, that's completely up to you.
Hey, Joseph.
Yes.
Is there a way how that's written in there that you could put like a minimum of 2.5 or even 2? So then you'll still get 3 if they're offering 3, but you have a minimum. I'm thinking the contract that I had in the state I was in before was structured differently. Mm-hmm. And I'm thinking for like Lennar homes that are only offering 1%, or in the case of a for sale by owner.
Right. So in that fee, yeah, to answer your question, this option 1 at the top, then yeah, that's where you would put that in there. So if you wanted to have a minimum fee, you would just put that in there.
The greater of.
Yep, it's the greater of.
So you could put something just as a minimum. Okay.
Yes. By the way, because we're on this note, commission's a very sensitive topic right now. Obviously in here it's fine because I'm the broker and we're all kind of in a safe place. There's a lot of stuff going on Facebook right now, and luckily not any from us. We had a couple of our agents that have commented on there. If people get into the discussion about whether or not they're happy because of what builders or what certain agents are offering, avoid that discussion like the plague in a public setting. It's a huge Department of Justice no-no. So that's just your side note. Okay, so Section 6, terms of the agency. Basically, this is where you'd put the terms of your agency agreement starting on X, ending in Y. Again, I'd say treat this the same way you would your listing agreement. Just have it expire the same time for everybody. It's either at the end of June or the end of December. That way you're not worrying about whether or not your contract expires at some odd day or odd month or anything like that. And then this is where it goes in the different areas where they've agreed or not agreed to participate in both. Well, first of all, they've agreed that you have shared with them the agency, different types of agency relationships in South Carolina, which I'm sure that all of you have done that prior to this. If you haven't, then you need to jump to that at this point because they're acknowledging it. And then it's basically at this point where you're going into either they are not going to allow dual agency or they are going to allow dual agency. And then the same thing with designated on both of these. And then just as a quick review on those, dual agency would really only be as if they have chosen to be represented by both you and as the buyer and the seller, meaning both the buyer and seller have chosen for you to represent them. Or if you did happen, if you and I were to happen to go under a contract, that would be dual agency, which that's not going to happen. And then if you are on a team, dual agency, that would be dual agency. It's going to be hard to say it's designated or out of that. Otherwise, in any time you're going to be with a Keller Williams agent, under contract with a Keller Williams agent in Charleston, it's going to be designated agency. Okay. Paragraph 8, Section 8 basically goes and is a disclosure again that other potential buyers have entered into a similar agreement may involve the purchase through the broker of the same or similar property. So this is just disclosing it again. Buyer consents to broker's representation of other such buyers. Broker agrees not to give buyers confidential information to such other buyers and not give such buyers confidential information to buyers unless otherwise agreed. This just goes further to explain what we talked about earlier. Paragraph or section 9 is another one that basically says that the buyer promises to disclose to the broker whether buyer has signed any agency agreement to any other broker. So basically this is saying what this paragraph says, Mr. Buyer, is if you have signed, you are not under contract with any other buyer agent to be working with them. So there is no conflict. Now, if they do say, yes, I have been working with one before, then you have to have them go back, talk to that agent about their agreement, and can really only represent them once that agreement has been has expired or they've negotiated whatever the terms were to cancel it. Do not get into any sort of conversation with them about how to cancel a buyer agency agreement. That's against license law. You would just simply say you're going to have to talk directly to that broker to figure that one out, to determine what your options are. In the event, section 10, in the event that the buyer wants to be confidential, then obviously this is where they're going to disclose whether or not that you as the broker have the permission to disclose their identity to all property owners and other third parties. This doesn't tend to happen on a regular, everyday real estate transaction. Should you get into luxury, high net worth clientele properties, this may be at that point where they would want, to know who the buyer is or anything like that. And at this point, the buyer will give you permission as to whether or not they want you to disclose that. Lauren.
I just have a question about this. How would you write an offer without disclosing who's buying the property?
A couple different, well, this also is not just from the purchase side. This is also would be on the showing side.
Okay.
So yeah.
I mean, there would be no reason at a showing to tell them their information anyway.
Well, some, depending on the type of property and the purchase price of the property, some would want proof of who the buyer is or that the buyer is capable of buying.
Gotcha. Okay.
11, basically the broker liability limitation. This is where they're basically going to be saying, I'm not an inspector, right? I am not an attorney. I'm not a tax person. I'm not, I can't give you expert advice on any of that. I'm a real estate person. I can give you information. I can talk you through this contract. I can walk you through the real estate market. However, the reason that we hire so many other people during the transaction is to have all the experts talking about their specification. So it's an important paragraph to acknowledge because it also helps you set the agenda as to how you're going to handle the inspector, how you're going to handle the appraiser, how you're going to handle the attorney. You're not going to be the messenger for everyone. You're going to be the one who puts everyone in touch. Make sure you know what the message is, but you're not going to be the one that's going to take the information from the inspector, decipher it, and then give it to the buyer. You're going to make sure that the buyer and the inspector are communicating directly. The buyer and the attorney are communicating directly. The buyer and whomever are communicating correctly or directly. Section 12 says you will not discriminate, right? This is still based on this form's a couple years old, so it hasn't updated as far as sexual orientation or identity. However, it does say these are the areas in which that we don't discriminate in this contract or in contracts in which we're signing to purchase real estate. In the event, this kind of paragraph 13 goes back to paragraph 11, says in the event that they do have information or a want for information in professionally specific areas, that they will seek professional counsel. And it lists in there some of the options, but not limited to attorney, tax advisor, lender, appraiser, surveyor, that sort of thing. This, by the way, a lot of questions I get from agents are, what should I tell my buyer about this? How should I advise my buyer about a net sheet? How should I advise my buyer about assumed closing costs, those sorts of things? This is where you engage your professional team. Nancy, that's a great question. Let's go set up a call with you and the lender so they can share with us from their expertise, what that looks like. You don't have to know all the answers, but you do need to know where to go get them. Section 14 says if we do come to a disagreement between us in this agency relationship, we'll mediate instead of sue. Any sexual, criminal information or sex offender information that you would need on properties, you would have to go look up it yourself. I can't provide that to you from the agency standpoint. Paragraph 16 says this is a binding agreement. It's a written agreement that we're going to. Paragraph 17 would be any contingencies that you would have, which we don't really put any contingencies in buyer agency agreements. You could put in here an easy out clause, if either party may terminate this agreement at any time in writing, if you wanted to do that. If you had someone that didn't want to sign a 6-month or wherever, and you were okay doing that. Section 18 and 19, pretty self-explanatory. 18 says that we can use fax as well as like other electronic means for signatures. 19 just basically says the buyers advise that properties that we go into may have both audio and video surveillance. So just beware of that. And if you have any questions or you have any comments, excitement, anything about the property, wait till we're back in the car or back at the office. Don't talk about it in the house or at the front door, just in case the seller is surveilling. And then part 19 basically says that it's a binding agreement. If you have any questions about the legality of it, and you have any questions, you can talk to an attorney. Otherwise, this is a real estate agency agreement. And that, in a nutshell, is a quick explanation of buyer agency agreement. Questions?
So this form is required in the state of South Carolina, correct?
Depends on, it's not technically required, no, but if you don't have it, you don't have agency, and now you're a transaction broker.
Okay.
So we don't typically allow, I don't want to say allow, we don't have transaction brokerage as a common thread in Keller-Williams, just because unless it's a situation where you represent a seller and it's truly a buyer that comes off the streets that you don't have any relationship with and does not want an agency agreement, then at that point you would just simply sign a transaction brokerage agreement with them. Technically, how South Carolina law is written, they default to transaction brokerage if they don't have an agency agreement.
Okay.
So, all right, other questions?
So once we get this this contract signed, do we upload it somewhere or do we bring it to you in the office?
You would upload it in Command. So once you get all set up in Command and the opportunities and get through the training on that, they'll show exactly where you would upload. You'd actually do it all through Command if you did it electronically.
Okay.
And then it's uploaded and submitted that way. Yes. Technically, if you want to look at it that way, it is something where, yes, you do hand it in or turn it in, but you turn it in through the system, right? Now, technically, state law says you would do it as soon as you have it signed. Most of you won't do it until you submit all your paperwork for the offer that they write. I would highly recommend that you would submit this right away, just like you would your listing agreement. All right. Any other questions?
So, okay, well, I'll go again. So after
Absolutely.
we get this signed, right? Then you guys go to work, and then once they do find a property that, they actually want to move on, that's when we go with signing, like offers from
Yep.
there.
That's the purchase and sale agreement.
Okay.
Yeah, and that's what we'll go over next week. So the first week we go over the listing side, second week the buyer side, next week we'll go through purchase and sale, and then week 4 we'll go through. Last time we went through inspections. I think that this next time we're going to go through reviewing the agency disclosure.
Okay. And I know, like, we're talking about how they have to get inspectors and different stuff, right? And we can't choose for them. We have to give them a list. Where do we get this list from? Did we just go and find them ourselves, or does KW have like a list of people that they recommend, or how does that work?
Yeah, so we have some internally that we recommend. I always recommend you go out and get into a relationship with inspectors or people that are in that, so you can have a good business relationship with them. But yeah, you can either way. We don't have preferred, so to speak, of that you have to use or anything like that. You can choose your own, but a lot of times it'll come from recommendations. And you'll figure as you get through Ignite in the process of getting your business and everything set up, there'll be different ways that you'll then find out, okay, here's the best way I'm going to go find inspectors for my list. I'm either going to go search them out, or I'm going to look for recommendations. That'll be up to you.
Nice.
I have a suggestion. I don't know how to pronounce your name. Is it Anikwa?
Yeah.
Yep, I'm Renee. Hi. So recently in our Facebook group for Keller-Williams, Charleston, West Ashley, I asked other agents for suggestions as to who they use, because I don't build a relationship there yet in Charleston to know a lot of inspectors. So that could be an option too, to get to know some names and research that way.
Thank you.
All right. Any other questions? All right. Short and sweet contract class, 35 minutes. Yay, yay, yay.
Awesome. Thank you.
If you have any questions, let me know. Otherwise, make sure if you don't have it on your calendar, go to the buyer consultation class tomorrow. And if you can't make it, be
Yeah.
on the lookout for the next one that comes around.
I'll be there. Thank you.
All right.
Thank you so much.
Bye, everybody.
Bye.